Hello, CRIM 4400. Today, Krissa, Marwal, Johnson, and myself, Pradeep, will be talking about ethical dilemmas faced by defense lawyers. To begin, we will dissect 3 ethical dilemmas that defense attorneys face, provide a reading that is relevant to some of the ethical issues discussed, and lastly, pose a scenario that you will work through via Moodle. So the 3 ethical dilemmas we will talk today is attorney-client privilege, professionalism and conflict of interest, and lastly, client advocacy. So first, to begin, I will take over. My name is Pradeep. I'll be discussing confidentiality, the first ethical issue a defense lawyer can face. So first, we will begin by talking about the significance of attorney-client privilege. All communications, written or oral, between a lawyer and a client are protected by a special right of confidentiality. This special confidentiality right is called attorney-client privilege. Confidentiality and attorney-client privilege can be seen under the same light. That is, attorney-client privilege is an important concept in Canada, among other countries, that allows clients to trust their lawyers with private information. The Supreme Court of Canada has called attorney-client privilege a principle of fundamental justice and civil rights supreme importance in Canadian law. Therefore, given its position to the relationship, we think it's important to understand what attorney-client privilege is. So what is attorney-client privilege? I actually found a definition that is particularly defined for our own province, British Columbia. In BC, a lawyer at all times must hold in strict confidence all information concerning the business and affairs of a client acquired in the course of the professional relationship and must divulge any such information unless expressly or impliedly authorized by the client, required by law or court to do so, required to deliver information to the law society, or otherwise permitted by this rule. Overall, this means that defense attorneys cannot reveal clients' oral or written statements to anyone, ensuring their utmost privacy. This includes prosecutors, friends, and family without their client's permission or consent. Attorney-client privilege also means privilege belongs to the client, not to the lawyer. This privilege exists whether or not the client asserts a claim of privilege. The decision to claim privilege must be that of the client, not of the lawyer, regardless of a lawyer's view about the validity of the potential claim. The privilege remains valid after the attorney completes the services to the client. And lastly, an attorney disclosing any information subject to attorney-client privilege is subject to ethical violations. So now we'll talk about the 3 preconditions. Therefore, in order to claim attorney-client privilege and keep otherwise relevant information private, 3 conditions must be met. The communication must be between lawyer and client for the purpose of seeking or giving or legal advice and intended to be confidential by the parties. So what is not covered by privilege? In other words, in some very exceptional situations identified in this rule, disclosure without the client's permission might be warranted. This can be only warranted if the law is satisfied that truly serious harm of the types identified is imminent and cannot otherwise be prevented. These situations are extremely rare, but do still happen. The first exception is future harm or public safety. Lawyers must disclose this information, but not disclose more information than is required. That is, the lawyer believes on reasonable ground that there is an imminent risk of death or bodily harm, and disclosure is necessary to prevent the death or harm. The Supreme Court of Canada has considered the meaning of the word serious bodily harm in certain contexts, which may inform a lawyer in assessing whether the disclosure of confidential information is warranted. For an instance, there was a case called in Smith versus Jones, and the court observed that seriously psychological harm may constitute serious bodily harm if it is substantially interferes with the health or well-being of an individual. So in all confidentially, particular attorney-client privilege can create many ethical issues. These include knowing the client's information is a serious threat. Does an attorney stay loyal to his client and upheld the attorney-client privilege, which means going against a professional code of conduct? Or does the attorney disclose this information without the client's consent and violate the relationship? The second issue could be how far is too far when maintaining the privacy of a client. And lastly, does attorney's reputation relationship with a client outweigh moral ethics? These are some major ethical dilemmas defense lawyers can encounter, something worthwhile to consider.
Hey guys, my name is Johnson Dang. Although you guys cannot see me, I hope you can hear me clearly. Today I'll be talking about the ethical issues in professionalism, but before we begin, I believe it is necessary to first talk about what exactly is a defense lawyer. According to the Department of Justice Canada, a defense lawyer is a lawyer who represents a person charged with a criminal offense. It is the defense lawyer's job to ensure that the rights of the accused are protected throughout the criminal process. One way in which I interpret this definition is that defense lawyers need to be fair to their clients. Keep this in mind as we go through further along in this presentation. Next up, I will be talking about what it means to be professional as a defense lawyer. What I mean by professional is in the sense where it is a form of standard in which all defense lawyers should follow. As we have learned in week 3, there is no better place to look for ethics and values than the Code of Conduct. As such, for this part of the presentation, I looked at the Code of Professional Conduct of the Law Society of BC. Obviously, I did not include everything from the Code of Conduct into this presentation, otherwise this presentation would take too long. I specifically chose 2 standards found in the Code of Conduct. The first being, it is a lawyer's right to undertake the defense of a person accused of crime, regardless of the lawyer's own personal opinion as to the guilt of the accused. Having undertaken such defense, the lawyer is bound to present by all fair and honorable means, and in a manner consistent with the client's instructions, every defense that the law of the land permits, to the end which no person will be convicted except by due process of law. The second standard that I chose is that a lawyer should never seek privately to influence a court or tribunal, directly or indirectly, in the lawyer's or a client's favor, nor should the lawyer attempt to curry favor with juries by fawning, flattery, or pretended solicitude for their personal comfort. The reason why I chose these standards among others is because the idea of fairness. Ideally, all officers of the courts, such as judges, prosecutors, defense lawyers, they should conduct themselves in a fair manner, much like how law is supposed to be fair. Now on to the ethical issue. A common ethical dilemma which can occur amongst all professions is what I would call the clash between professional ethics versus personal ethics. Just imagine a scenario in which you are a defense lawyer who is responsible for defending a client who is accused of very heinous crimes. Can you ensure that you can provide the best quality of service towards your client? This is important because, as I previously mentioned, law is supposed to be fair. In any criminal case, there is already one side, namely the prosecutors, who are trying to build a case against your client. And as a defense attorney, if you are not trying your best to help your client, then you are clearly not acting like how a professional should be. Ask yourself this: is this truly fair to your client? Most people would say no, it's not fair. I will not go too much in detail into this type of scenarios because it somewhat relates to client advocacy. In regards to the second standard in which I mentioned, try to imagine a scenario in which you heavily value being the best of the best. As a defense lawyer, you have never lost a case. However, now you are faced with a case in which the result is heavily influenced by the jury's decision. What do? Is your personal ethics more important than professional ethics? Will you bribe the jury to influence their decision, just so you can maintain your reputation as best of the best? Take some time to think about it. These scenarios may seem far-fetched and somewhat on the extreme side, and you might wonder if these actually occur in real life. I can tell you, yes, they do occur. I can name one infamous defense lawyer, Paul Berggren. He was once a famous defense attorney who practiced law in New Jersey in the US. He is also known for being a lawyer who had a witness killed in a drug case, hired a hitman to kill another, and used a restaurant as a front for a cocaine ring. This man obviously chose personal values over professional values. And this also brings up something that I want to touch upon, which is one of the topics that we learned in our first year criminology courses, which is the idea of the dark figure of crime. A quick recap in case people don't know what it is or forget what it is. The dark figure of crime is a term often used to describe the amount of unreported or undiscovered crime. This concept of a so-called dark figure of unreported or undiscovered incidents is something that I believe exists for all professions. The idea in which the incidents that we do see or in which is reported in the media is only but the tip of the iceberg. This is the proof that there are people who choose personal values over professional values. Next up, we're going to be talking about client advocacy.
My name's Carissa, and today I'm going to spend some time talking to you about client advocacy. So first, what is client advocacy? It is when a lawyer advocates for their clients' wants and needs. Law firms face ethical challenges every day when determining how best to advocate for their clients. The reason this can be viewed as an ethical issue is because at times there are scenarios in which, although a lawyer is fighting for their client, there can often be other parties in the crossfire, which is exactly the next point. What happens when a lawyer is forced to win at all costs, but the best interest of another party is at stake? For example, in emotionally taxing cases, such as child custody cases or domestic abuse cases, this is, exactly the case. A defense lawyer might be doing right by their client and winning at all costs, but what about, a child in question? So that's kind of where the next clip takes us. It's from a classically hilarious movie that I'm sure many of us have seen, so take a look.
I understand both parties have agreed to joint custody, is that correct? Yes. No. I'm contesting custody. What? If I get sole custody of the kids, there's another 10 grand in child support payments. You just won $11 million. I'm the victim here, you said it yourself. I'm gonna hit him where it hurts. So? Well, Mr. Reed, do we have an agreement on custody or not? In that case, there will be a custody hearing on the 19th at 9 a.m. Court is adjourned. Come on, let's go. Daddy, you stop that whining or I'll give you something to whine about. Daddy! Come on, it's all right, don't you worry. Promise we'll be together when it comes. It's okay. I'm saying, will you give me those? They're mine. Let go of Daddy. Let go of him. Let go of Daddy. We're leaving now. You think, come on. Don't you have some chips to bite? You haven't paid for it yet.
So in this case, although the lawyer, may win a case for their client, they're often faced with ethical improprieties that have, consequences down the road. In this example, he's potentially robbing a child of a stable and loving home by fighting for sole custody. So how does a defense lawyer balance those, ethical decisions? An interesting kind of example I found in Ethical Dilemmas in Law Firms magazine, an online magazine, said a lawyer might be asked to allege that a parent molested a child when the lawyer doesn't believe the parents committed this crime. So law firm managers have to frequently balance ethical considerations with zealous advocacy for their clients. It's basically how far are they essentially willing to go to advocate for their client. Another example of client advocacy would be in domestic abuse cases. If a lawyer is defending the perpetrator or the aggressor in the case, how does that impact the victim of the domestic dispute case? If you're fighting for the rights of an aggressor, you have some sort of ethical responsibility towards the victim of that crime. So, just a quote from Martin Luther King that I found interesting is, "An injustice against anyone is an injustice against us all." That being said, on the flip side, advocating for their clients, obviously is a key component for a defense attorney. Of course, they want to win; that's a given. But they are forced to balance some very heavy, and emotional, topics. One of the books that I found online, The New Lawyer: How Settlement is Transforming the Practice of Law. In this book, Julie McFarland touches on some key concepts for client advocacy. The style of advocacy that we associate with lawyers in the 21st century is more needlessly adversarial and somehow less noble and dignified. So that just kind of sums up that the lawyer's adversarial role is to win. That's the ultimate goal, and client advocacy kind of comes second in the 21st century. Another interesting fact in McFarland's book was the difference between the country lawyer and the city lawyer that she touched on. Defense attorney in the country has to handle each case with extreme care, for the population is less than that of a big city. That being said, it kind of turns the big city lawyers into kind of aggressive and adversarial lawyers rather than focused on bringing about quaint but concise change for their clients.
Hi, my name is Marwa, and I'll be covering up the other resources we used in this group project. So, due to this pandemic, it was difficult to get a hold of an interview with a defense lawyer. None of us group members had any contact with anyone from this field, so we decided on finding brief interviews on YouTube that explained the main premise and questions we were wondering. Luckily, I found these YouTube videos that cover up all our concerning questions we wanted to get an answer of if we were to interview a defense lawyer in person. So video 1 is the first video that will be explaining the compassion of a defense lawyer in their occupation. It will give a sense of what the main premise and the goals of a defense lawyer is to their client. This video will be really informative because you can pick up the idea that not every accused is guilty of an offense. The defense lawyer will give an insight to why being a defense lawyer is important. In this video, the criminal defense lawyer states his clients are just citizens accused of a crime, and it does not mean that they're guilty and that they deserve a good defense no matter what they have done. And it is the Constitution that all defense lawyers need to follow to help their accused client. It is also not the job of the defense lawyer to prove the case. It is the prosecutor's job. But the defense lawyer is there to represent the person that is accused and help defend their accusation to the court. The first time meeting is always confidential between the client and the lawyer. And as stated in our slides, one of our ethical dilemmas for the defense lawyer is confidentiality. It is an integral part of the defense lawyer's job to ensure that there is privacy and the information between the defense lawyer and the client is under the strict guidelines of confidentiality, otherwise there would be an ethical violation. For video 2, defense lawyers work hard to have a positive impact for the criminal law as a defense lawyer. Defense lawyers deal with complex concepts and compressing them to something persuasive to convince the judge that the accused is not guilty of an offense. The hardest part about being a defense lawyer is that there is little time and resources that the lawyer has to tackle with, and it can be hard to deal with human consequences when dealing with criminal law. There is a lot of one-on-one interaction between the accused and the client. The criminal lawyers spend a lot of their time looking for information, which means that they need to look for important facts and go over a lot of documents in order to help their client. There is a lot of work put into being a criminal defense lawyer because defending an accused has a lot of challenges. Experience is really important in order to grasp the idea of how the system works and to get into criminal law. For example, mooting and trial competitions helps build hardcore legal skills, and it will help with the day-to-day work. For our outside resources, we decided to use an article that discusses about ethical issues. There was an interesting journal article that talks about the ethical issues involving social media and how lawyers use it in their profession. These ethical issues were discussed by an opinion on the ABA Standing Committee on Ethics and Professional Responsibility, which discusses ABA model rules of professional conduct on lawyers who engage with the public and reveal confidential information of their client with the use of social media. It is an interesting topic that gives an idea on how important professional conduct is and how sharing information of their cases and clients to the public can violate the rules. These rules are from an American perspective on lawyers and the ethical issues that can occur with the use of social media. 10 ethical issues were discussed in the article. I will be reading these ethical issues briefly. So 1, lawyers should understand the opportunities and downfalls with social media. Many times they get in trouble misusing social media. Lawyers should provide competent representation to the client, which involves skill, legal knowledge, and thoroughness. The lawyers should have knowledge of the benefits and risks of using technology and must have a complete understanding of those factors. 2, lawyers should be familiar with social media to screen their opponents or clients' posts for relevant information. This means that the lawyer needs to act in a responsible diligence in representing the client. The lawyers must advise their clients on social media posts that can affect the case, and they should also know how to seek evidence for their cases so there are no surprises. 3, lawyers should not share any privileged or conditional information on social media. Lawyers should always obtain their clients' consent before publicizing any information to their websites or social media. 4, lawyers should not pressure relevant social media evidence and unlawfully conceal or destroy possible evidence. This means that the lawyer should be fair to the opposing party and counsel. There should also be no false evidence or witness that can easily falsify it. Number 5, lawyers should not communicate social media with a person represented by counsel without the person's lawyer's consent. This is because the person can have social media connections. 6, lawyers should not make legal advice or misleading statements on social media. There should be no dealings with people that are not represented other than the client. 7, lawyers should maintain respect and be careful to third persons on social media. Many third parties can gain access to private settings, and it's the lawyer's job to disclose the status for the possible communication. 8, lawyers should not have misleading or false statements on social media on the lawyer's achievements, abilities, and credentials. It can lead to misrepresentations, and it can cause misleading information about the lawyers that are not true. Number 9, lawyers cannot make misleading or false statements on social media about specialty certification or specialize in particular field of law. 10, lawyers should not use social media as a means to act in misconduct. There should be no attempt to violate the rules of professional conduct. By reading these ethical issues, it is interesting to know how many ethical issues are identified for the topic of lawyers and the use of social media in their profession. This shows that there are many possible ethical issues that can occur with the lawyers. While reading these ethical issues, all of these ideas fall into our 3 identified ethical dilemmas of confidentiality, professionalism, and client advocacy. Our 3 ethical dilemmas are identified to be in very specific categories that we think that are the main ethical dilemmas for defense lawyers. Those 10 ethical issues cover mostly about how the information of the client and the lawyer should be confidential and private, and how social media should be carefully used when dealing with cases. This also falls into the idea that professionalism is important and there should be no third parties or people involved that can affect the case. Client advocacy is really important because if their information is shared on social media, there is no professionalism involved and the arguments for the client in the courtroom can be weak. By reading all these ethical issues in this article, it is similar to our 3 specific ideas because all these 10 issues written in ABA model falls under our identified ethical dilemmas. These are the references that we used throughout our slides. And thank you for watching.